Namaskaram. Hello and welcome, hardworking individuals. Do you know about that case of India which stood for women empowerment as well as which changed the law of the nation and the law of a religion? This case was not only limited to Shah Bano, but it had a huge impact on Indian politics, which started with the right of a women to Muslim appeasement and then went on to counterbalance with opening the locks of Babri Masjid for the prayers to be done of Ram Lala. Yes, we are going to talk about the Shah Bano case, and it's not only limited to Shah Bano, but we will also talk about the triple talaq, the Muslim personal law or the Sharia. We will talk about what is the Sharia law, as well as we will talk what changed in the comparison of the laws that were there and what is the current status. So let's get started and what actually it was. So it starts with the marriage between a very famous lawyer, Muhammad Ahmad Khan, and there was this Shah Bano Begum. And she was a 62-year-old Muslim woman from Indore, Madhya Pradesh, and she was married to Muhammad Ahmad Khan, who was a prominent advocate, and the marriage started since 1932. After 46 years of the marriage and 5 children, Khan took a second wife and subsequently evicted Shah Bano and their children in 1978. As you know, it's allowed in the Muslims to marry 4 wives. So that was done and that was well within the Muslim laws. But when he stopped paying the promised monthly maintenance of rupees 200, Shah Bano filed a criminal petition act under section 125 of the CRPC. Now, and she sought a maintenance of rupees 500 per month. In November 1978, we'll see Khan pronounce the triple talaq, that's the instant divorce by saying talaq 3 times, and dissolved the marriage and argued that he has no longer obligation to maintain her, claiming that he had already given the 5,400 rupees that was an obligation under the Islamic law. The local magistrate initially awarded rupees 25 per month to Shah Bano, which was later enhanced to rupees 179.20. That's 179 rupees and 20 paise by the Madhya Pradesh High Court. But then this case was taken to the Supreme Court, and then there was this landmark judgment of the 5 judge bench, which was led by Chief Justice Y.V. Chandrachud, and it ruled in the favor of Shah Bano. It stated that the section 125 CRPC, that was a secular law applicable to all citizens regardless of religion, and entitled Shah Bano for the maintenance. Now, the court also emphasized that the divorced Muslim woman could claim maintenance under the secular law even after the iddat period. What is the iddat period? It considers that after a Muslim person gives talaq to the women, there is approximately 90 days time that he has to give the maintenance to the women. After that, it is not the duty of the individual male. Now, significantly, the court also for the very first time talked about the uniform civil code, because otherwise every religion will have their conflicting laws, and if we are emphasizing on secularism, it should be there. Now, when the judgment came, it had a political backlash. At that very time in 1984, it was a grand victory for Indian National Congress under Rajiv Gandhi. And Rajiv Gandhi was made to believe that the Muslim vote bank can get away from him. Now, under this immense pressure, Rajiv Gandhi government, despite initially supporting the verdict, performed an about face. Now, what was that? In 1986, Parliament passed the Muslim Women Protection of Rights on Divorce Act 1986, which effectively nullified the Supreme Court's judgment. Now, this act restricted Muslim husbands' maintenance liability to only the iddat period that was already there. Now, if a woman could not support herself after iddat, it said that the responsibility was not of the husband, of the ex-husband, rather it was on the relatives or the state waqf board. Now, if you talk about this judgment that was there, it stood for the empowerment of Muslim women, because like all the women of every religion, Muslim women does also have the right. And it also asserted secularism, as we have already seen that the Supreme Court says that there should be uniform civil code, that's the UCC. That's still not implemented in India, by the way. There was this judicial activism where we see the case demonstrated the Supreme Court's willingness to interpret laws progressively and protect women's rights even when facing political opposition. Subsequently, there were legal developments that we see in the landmark Daniel Latifi. Who was Daniel Latifi? He was the lawyer of Shah Bano. And there was this case in 2001 where Shah Bano's lawyer challenged the constitutional validity of the 1986 Act. And the Supreme Court, while upholding the Act's validity, interpreted it that it meant that a Muslim husband must make reasonable and fair provision for his divorced wife future needs at the time of divorce, not just during the iddat period. And this effectively did what? It effectively restored the spirit of the Shah Bano judgment. Now, what is this triple talaq actually? Triple talaq or talaq-e-biddat, that is what it is called, is the controversial practice where a Muslim man could instantly and irrevocably divorce his wife by uttering talaq 3 times successively. And it can be done by writing as well as in the SMS or email. Now, there was this Shikara Bano case. Now, this is different from the Shah Bano case that was in 2017. And here we will see that on August 22, 2017, a 5-judge constitution bench declared triple talaq unconstitutional by 3-2 majority. And what was the judgment there? Manifestly arbitrary and discriminatory against women, that's the triple talaq, violated fundamental rights under Article 14, 15 and 21 of the Constitution. Not an essential religious practice. This is something very much needed to be understood, that it was not a core part of Islam and contrary to the basic tenets of Islam as emphasized in the Quran. Now, the Muslim Women Protection of Rights on Marriage Act 2019 was there, and this void and illegal. This made the triple talaq void and illegal, a cognizable offense punishable with imprisonment up to 3 years and a fine, entitling the divorced women to seek substance allowance for herself and also subject to bail and compounding only after hearing the women and with the magistrate's satisfaction. So the act became effective from September 2018 and was notified as law in July 2019. That was against the triple talaq. Now, what changed in comparison to the earlier laws? So if you see for the maintenance period, while the under section 125 CRPC, lifelong or until remarriage, that was there, 1986 Act limited to iddat period only, that is 90 days. But current status what it is, reasonable provision for future needs, section 125 CRPC as well as section 144 BNSS applicable along with 1986 Act. For the triple talaq, it was legal but challenged in 1985. Legal under personal law in 1986, but completely banned and criminalized in 2019. What about the husband's liability? Continuing obligation ends after the iddat and must make fair provision at divorce time extending to wife's future. That's what the current status is. Legal resource, section 125 CRPC, 1986 Act, obviously for the 1986, and both section 125 CRPC and 1986 Act, women can choose remedy. And divorce initiated by women, there was limited options in 1985, also limited options in 1986. But now khula, what's khula? And this is something where wife calls for the divorce, recognized as absolute right without husband's consent. This was given by Telangana High Court in 2025. Let's see about that judgment as well. The court reaffirmed that divorced Muslim women can claim maintenance under both Section 125 CRPC as well as under the Bharatiya Nagrik Suraksha Sanhita 144 and the 1986 Act simultaneously. Women divorced by invalid triple talaq can have the maintenance rights. Section 125 CRPC provides secular constitutional protection, and also Muslim women enjoy equal rights. Okay, this was under the July 2025 and Telangana High Court judgment of June 2025. Let's see that. The court held that a Muslim woman's right to seek khula, what's khula, wife initiated divorce, is absolute and unconditional, requiring neither the husband's consent nor approval from the religious bodies like the muftis or Darul Khaja. This represents a significant advancement in women's autonomy with Muslim personal law. Now, what is this Sharia law? Okay, Sharia, that's Arabic for path or way, is the divine Islamic legal and ethical system that governs all aspects of Muslims' life, including religious obligation, personal conduct, family matters, business transaction, and criminal law. There are some primary sources like Quran, the holy book of Islam, serving as the fundamental source. You also have Sunnah or the Hadith, the teachings, saying, and practices of Prophet Muhammad. Secondary sources like the Ijma, that's the consensus of Islamic scholars on legal issues. Qiyas, that's the analogical reasoning to derive rulings for new situation by comparing it to the similar cases. And you also had istihad, or now what's that? Independent reasoning and interpretation by qualified scholars to address contemporary issues. Now, application in India, if you see, of the Muslim Personal Law, the Shariat Application Act 1937 governs personal matters for Muslims in India, including marriage, divorce, maintenance, dowry, guardianship, inheritance, gifts, trust, and waqf charitable endowments. The act mandates that the court apply Muslim personal law in these matters, notwithstanding any custom or uses to the contrary. So this is what the Shah Bano case stood for. There is this question related, if you are preparing for an examination, it can be asked. Very simple, which one of the following was the key legal provision invoked by Shah Bano? It was section 125 of Code of Criminal Procedure. You can pause the video and see the explanation. The enactment of which law by Indian Parliament in 1986 is considered legislative response. Obviously, it is Muslim Women Protection of Rights on Divorce Act 1986. And then you have this question where it talks about the reference to Shah Bano case, subsequent legal development. Which of the following statement is or are correct? The Supreme Court advocated the implementation of a uniform civil code. Yes, it did. The 2019 law made triple talaq a punishable criminal offense. Yes, it did. And the Daniel Latifi versus Union of India case, maintenance for Muslim women, was limited strictly to iddat period. No, it was not limited strictly to iddat period. 1 and 2 should be the correct. You can pause the video and see the explanation. Well, as I said you that it had huge impact on Indian politics, and that was the time since when the Muslim appeasement especially started, which was started by Indian National Congress and then later on cast by the different political parties. What do you think about it? What you really think does really matter, because a single case and a single woman can change the course of the politics and of the law. So your thinking too can do the same. We'll meet again if you subscribe. Namaskar.